Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Let's get started and look into the first article. The first article says, not just a case about improving investigation. What is this article speaking about? The article here draws a reference to the recent Supreme Court judgment. One is with respect to the Evidence Act. The other is with respect to the Code of the Criminal Procedure, the Criminal Procedure Code. And then the author introspects about the judgment made by the Supreme Court. The Supreme Court said that there has been a lacuna when it comes to the implementation and the Code of the Criminal Procedure, and when it comes to the implementation procedure followed by the police officers. While this may be accepted, the author also says that there are other issues with respect to the investigation, that is with respect to the manpower, the police power, and also with respect to the state responsibilities as well. So the author goes on to say that the police officers may not have been conducting the investigation in the right way. The entire onus and the responsibility is not just with the police officers, it is also with the state as well, because the state has to ensure that there is enough manpower. The manpower is employed in such a way that they are able to expedite the entire process of investigation. Since the state has also not taken the responsibility, blaming it squarely on the police officer may not be right, says the author. This is the gist of the article. Now let's understand this in an elaborate way. What is the author trying to say? Recently there was a judgment given by the Supreme Court of India in Rajesh and Ananda versus the state of Madhya Pradesh. What exactly happened in this particular case? The Supreme Court had to acquit three accused. So there were three accused people, three individuals who were arrested, and ultimately these three people who were arrested were acquitted. They were not convicted. What is the difference between conviction and acquittal? When it is conviction, it means that all the charges that have been put on a person is right and it has been upheld, and as a result, when there is conviction, this person will be thrown behind bars. But what happens in an acquittal? The person might have been charged with a particular crime, or so and so offences would be squarely put on that person, and after all the evidences are put before the court of law, the court of law considers this evidence and ultimately says that this person is absolved of all the charges, which means that he is free to go and he will not be thrown behind bars and will be re-released into the society. So in conviction, he'll be thrown behind bars. In acquittal, all the charges will be absolved and he will be released, and there will be no more prosecution on this particular person for that specific case. In the recent incident in Rajesh and Ananda versus the state of Madhya Pradesh, we have the Supreme Court of India which acquitted three people, and as the acquittal happened, the Supreme Court also said that the police officers and the investigating agencies do not have a consistent and a dependable code of investigation. And it also looked into the matter that Justice Malimat Committee had recommended that we require the reforms on the criminal justice system. So what we have to look into is those aspects that have been envisaged by the Malimat Committee. The Malimat Committee was appointed by the Government of India basically to look into the criminal justice system. The criminal justice system should have been revamped. What it requires is more manpower, more police officers. Investigation will have to be expedited as well. And when it comes to the investigation, what is the main issue? One, what we have is the police officers who will be employed for the law and order issue, and police officers who will be involved in the investigation. What is police officers in the law and order? They would basically prevent undue incidents from occurring. Like say for example, there is a riot-like situation, or there is chaos in the society, or there is massive number of people who come up to a particular area. This may create public order and law and order issues. So police officers will be employed in law and order and public order issues. So they are engaging in a certain section of work where they should ensure that there is no peace and tranquility which is disturbed. So what is law and order issue? Police officers will be employed that there will be no untoward incidents that is happening in the society. That is the first work of the police officers. While we discuss this aspect, let me also give you another difference as well. There is law and order, then there is public order. What is the difference between law and order and public order? Let me give you an example. Let's say there are two individuals who have boozed. They are in a tipsy state. They are not able to get a hang of what is happening in and around them. So there are two individuals. Let's say for example they are from a different community. Let's say for example they follow different religions. They are from two different communities. So these two people, they have boozed. They are in a tipsy state. They start brawling against each other. They are in a fight against each other. If it is only with respect to those two individuals, they are creating a nuisance, and it is only these two individuals who are fighting with one person and another. That is what is called as law and order. Law and order basically means that I have an issue with you, both of us are fighting it out, so we have an issue, there is an illegal thing that is happening, but only two of us are involved. One is me, the other one is you. So since there is an illegal act that is connected between me and you, or one person and another person, that is what is called as law and order issue. There is an illegal issue, but then this is with respect to one individual and another individual. But what happens when it comes to public order? When it comes to public order, let's say these two individuals who have boozed, these two individuals who have drunk, they are in a tipsy state, are from two different communities. So these two different communities are fighting with each other. So it is not just one individual versus another individual. When two communities, because of these two people, two community people, two religion people come against each other, it is creating a chaos, it is creating a recklessness, it is creating a problem in the society such that the entire public gets involved. So when large number of people are involved, that is what is called as public order. When only two individuals are involved, that is called law and order. So where are the public involved? So where are the police officers involved? So the police officers are involved in the law and order problem issue. They are also involved in the public order issue. Malimat committee said that when it comes to police officers, one, they are involved in the law and order and public order, and at the same time they are also involved in the investigation as well. What is investigation? Let's say for example there is a murder that has occurred, or there is a rape that has occurred. Who has conducted this particular rape? What is the prima facie evidence? What is the appeal to this particular scenario? How this person has conducted it? Who has conducted it? When he has conducted it? What was the mens rea in this particular case? Everything has to be investigated by the police officer. Let me give you another point here. Whenever we are speaking about criminal justice system, what you have to remember is there are four fundamentals when it comes to the criminal justice system. One is what is called as the mens rea. Okay, this is called as mens rea. Second is what is called as actus reus. What is mens rea? Let's say for example there is a person who has committed a crime. This crime, when he has committed it, does he have a guilty mind? What is guilty mind? I should have pre-planned it. I should have made sure that this person has actually committed that particular issue with a guilty mind. So I should have planned it, I should have pre-planned it, I should have engaged other people. So do I have a guilty mind to commit that particular offense? So if I have to give you a clear explanation what is mens rea, let me give you an example. Let's say there is a person who is driving a car. This person is going at about 40 or 50 kilometers per hour. He is going at a normal speed, but all of a sudden there is a child that appears. It's not in his vision, it is nowhere seen in his vision, but all of a sudden the child is on the pedestrian path. It moves all of a sudden to the road. So the person who is driving the car kills that particular child. Was this person guilty of killing or murdering that particular child? No. Why? Because he did not want to kill that particular child. The child killed all of a sudden, and he happened to kill that particular child. In this particular case, the mens rea is absent. Now, let's assume for a moment that there is a child. The child is playing. There is a person who is coming and driving in. He is coming at 100 or 120 kilometers per hour. He knows for the fact that if this particular child is killed, entire assets and the wealth of that particular child and the family's property will come to that particular person. So, he is driving at around 120 kilometers per hour. There is a child which is just sitting in that particular place. He drives intentionally intentionally. So when he drives intentionally, that is what is called as guilty mind. So mens rea basically means whether a person has guilty mind or not. And what is actus reus? Actus reus basically means that there is an action, there is an initiation, there is a process where an action has taken. So whenever a murder is being initiated, a person should have a guilty mind, and at the same time I take a knife, I kill him. So there is an action that is initiated. Or for example, I hit a person on a person's head. So there is an action that is initiated, which is called as the actus reus. So when it comes to the criminal procedure, what we have is mens rea, which happens one of the aspect, actus reus another important aspect. So what is the Mallimath committee saying? That when it comes to the Mallimath committee, it says that police officers are engaged in the law and order and public order issue. They are also involved in the investigation as well. So these two things have to be separated. Why should they be separated? That is because so that it increases the overall efficiency when it comes to the police operations. So in this particular backdrop, this judgment Rajesh and others was a state of Madhya Pradesh that was given by the Supreme Court recently said as a major reform that has to be introduced to the police system, what they have to do is differentiate between law and order and investigation. So if law and order is separated and investigation is separated, what we will have is utmost efficiency when it comes to the police officers and the police reform. The author also brings into picture two important aspects about the recent judgment in Rajesh and another versus State of Madhya Pradesh. One is with respect to section 27 of the Evidence Act. The other is with respect to 100 of the CRPC. What does section 27 of the Evidence Act speak about? How much of information is received from the accused may be proved, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of information, whether it amounts to a confession or not, as relates distinctively to the fact thereby discovered may be proved. Whenever you speak about confession before the police officers, what exactly happens? Generally, confession before the police officers will not be considered. When you go to the court of law, the first question that you are asked in case you have committed a criminal offence is, have police officers hit you, caned you, belted you, so on and so forth. So there will be an accused who will be in the box. There will also be a court officer. Then you will also have the presiding officer who is the judge. So the clerk or the the court officer will ask a question to the accused that this police officers hit you or something like that. Then the accused usually denies that the police officers did not hit them or cane them or belt them, so on and so forth. Why? That is because all the confessions that are made before the police officers are not admissible. These are not confessions. Now another question is, what is the difference between admission and confession? Let me explain with a simple example. Let's say, for example, you go to the police station and the police are investigating, or let's say even before the court of law as well. They ask you, what is your name? I say, my name is Ajay Narayan. And they ask me, where did I study? I studied in so and so college. Where are you working? I'm working in so and so place. So this is the admission. So the information that you generally give is the admission part. Now they ask me another question, that did you commit a murder? If I say yes, that becomes the confession. So all admissions are not confessions, but all confessions are admissions. What do I mean by it? When I say that there is a particular question that is asked in the court of law by the advocate and I happen to admit it, and this admission is in such a way that it ultimately leads to a point that I am accepting that I have committed this particular crime. So if a particular committal of the crime's acceptance is proved by me, I have accepted that particular crime, that is what is confession. So in admission, what happens? I answer all the questions of the advocate, but in confession, what exactly happens? That answer, that admission I have given will ultimately prove that I am guilty. That is what is called as confession. So what happened in this particular case is that under section 27 of the Evidence Act, let's say for example, whatever I have given before the police officers, it may not be accepted as confession. Even if I say that yes, I did kill that particular person, since I am saying it before the police officers, that is not accepted as an evidence evidence before the court of law, because section 25-26 speaks about confession before the police officers. So even if I say that I committed that particular murder before the police officers in police station, that may not be acceptable to the court of law. Only if I have made it before the court of law or when there is a magistrate before him, that is what will be accepted. But an exemption to this is what is given under section 27. What exactly happens? Let's say there is a police officer, they are investigating, and while the investigation is on, they ask me a question, where is this particular knife? So I happen to kill a person, so they ask me a question, where is this knife? So I say that I took this particular knife, I killed this person, I threw it in the garage. So what do the police officers do? They go to the garage and they ultimately find out that this knife is actually present in that particular place. So they pick up this particular knife with a gloves obviously, and they take it and put it as an exhibit and bring it before the court of law. So this knife will have my fingerprint. So this fingerprint will ultimately prove that I have committed this particular murder. So what exactly happens in section 27? In 25 and 26 it says that confession before the police officers may not be right, but in section 27 it says that if there is a discovery of a discovery of a property with which information that I have given to the police officers, if that can be proved, that can act as an exception to 25 and 26, and this property that they have recovered can ultimately be accepted as a confession by me before the police officers. But this is where the author goes on to say that in the recent judgment, the Supreme Court of India under section 27 of the Evidence Act reinterpreted the section 27. What did they reinterpret? A person could not be said to be in police custody till he was formally arrested, as he did not figure on an accused person in the first information report and was not accused of any offence till his arrest. So who is an accused? Accused according to the recent interpretation by the Supreme Court of India, only if such a person is present in the FIR. We have the FIR, that is the first informational report. In the FIR, if a person's name is present, only that person, if he makes a confession, that is what is acceptable, says the Supreme Court of India. But the author says even a person whose name is not in the FIR, if he is made a confession under the police custody, even that can be taken. So what is custody here? The interpretation of custody made by the Supreme Court is that Supreme Court in this particular case says that his name should be there within the FIR, and at the same time he should be behind the bar, he should be present. That is what is custody. But the author says that is not custody. The author says that literal interpretation should not be taken up, but even if his name is not in the FIR, that can also be custody. When he is under the watchful eyes of the police officers, that is also custody. The Supreme Court says his name should be in FIR and he should be behind the prison, and only when he says something that can be treated as confession if there is discovery of a property. But the author says it is not within the precincts of the four wall, and it is not when FIR mentions its name. Even if there is no mention of the name in FIR, and even if he is under the watchful eyes of the police officer, despite he not behind the prison, that can also be assumed as confession if a property is recovered. To substantiate it, the author brings into picture a couple of judgments. In Mansingh, the court held that the word custody does not necessarily mean detention or confinement. The submission to custody by any action or words is also custody within the meaning of the section. Even indirect control over the movement of the suspects by the police has also been held to have police custody. So police custody is not definitely about that person staying in the prison, but it also means that if he is being watched, constantly being monitored by the police officers, even that belongs to custody, says the author. In Chotayal vs. State of UP and many other similar cases, the court has also held an accused is in the police custody within the meaning of the section when he is under surveillance of the police and cannot break away from the company of the police. So the Supreme Court in that judgment, in the recent judgment, has said that his name should be in the FIR, this person should be in the police station or within the four walls of the prison, but the author says it not necessarily have to be in the FIR, and at the same time, even if he is under the watchful eyes of the police officers, that can also be interpreted as custody, says the author. That's the first one. The second is with respect to 100 of the CRPC. When you look at section 100 of the CRPC, it speaks about persons in charge of close place to allow the search. What is the section all about? Let's say, for example, there is a case that is in picture. So the police officers have got some tip or some information, and they say that there is a particular crime that is happening, or for example, let's say for the sake of example, there is a prostitution racket that is being performed in a particular area, in a particular region. So the police officers have gotten information. So the minute they've got this information, they go to that particular place and they also start investigating. Even before they go for an investigation, they also will have to take with them upon 2 or more independent and respectable inhabitants of the locality in which place to be searched in statute or in any other locality. If no such inhabitant or the said locality is available or is willing to be a witness to the search, to attend and witness the search, and may issue an order in writing to them or any of them. Let me simplify this process for you. So whenever I go for the investigation, let's say in a particular place, I get a call that there is a prostitution racket that is going on in a place. So whenever I go, there might be false allegation that may be imposed. In order to avoid it, let's take 2 to 3 people in that particular localities as panchnamas. Panchnama basically is about 5 people, but in this particular case, let's say 2 to 3 people I take to that locality to prove that whatever tip I've got as an information is also right. It is not just validated by me as a police officer, but there are 2 to 3 people in that respectable area who are also present with me. They are also seeing it, they are also witnessing it, and they are also saying that yes, this particular issue is occurring in that particular area. So there is validation to the police officer's claim as well. That is what is 100 of 4. But the author also says that in Mushir Quran at Bacha and another was the state of MP, the court held that if discovery under section 27 of the Indian Evidence Act is otherwise reliable, its evidentiary value is not diluted just by the reason of non-compliance of section 104 or section 105 of the CRPC, which means even if there are no people, but if there is a property that I have discovered in that particular place, despite people not being there, if there is a property I have discovered in that particular place, the presence of the inhabitants or the local people is not necessary. It says Mushir Khan at Badshah Khan and another was a state of UP. So what is the author trying to say? According to the new interpretation that the Supreme Court has made recently, they are very specific about independent and respectable inhabitants. So if you're going to a place, you have to follow the law strictly, that you have to take the place and ultimately you've discovered a property from that particular place. Ensure that 100 of 4 is present where you are taking the local people while you conduct that particular investigation. But the author says that if I have to discover a property, these people are not a necessity because I'm only taking and discovering that particular property under section 27. So the author says these 2 interpretations that have been made by the Supreme Court may not be right because there have been past precedents of the Supreme Court which is against this particular notion. So the author says blaming the police officers entirely may not be right. Why? Because there are other things that are also in picture. That is because the author goes on to say that yes, investigation is still poor and the principal cause of low conviction is also because of the police officer, but it is not just because of the police officers per se, but it is also because of many other factors. That is, the police stations are understaffed, sufficient priority is not given for investigation of crime, and there is no periodic exercise to upgrade the skills of the investigation. So the Supreme Court had said that the states will have to devise a plan where one is for the law and order, the other is for the investigation. When most of the officers who are present in the state police are always involved in law and order and public order, how will they upskill themselves? How will they go and study about the investigation method? When will they get the time to study and rework on their skills? Since they are not given time to rework on their skills, it is the state which has to provide time and the resources to the police officers. So blaming the police officers entirely may not be right. That is because the state has to give enough time as well on one side. On the other side, we require enough manpower as well. When you look into the data, 17 states have taken measures to separate the investigative and the law and order functions of the state. The remaining states are not opposed to this directive but have not initiated any steps whatsoever. When it came to the overall complaints of 7 directives, 9 states fell under good and satisfactory category, 20 states in the average and poor category. However, going into the details of responses, one could decipher that most states have either made some provision in their state act or issued administrative order. When the state is not looking into these aspects, why blame the police officers entirely is one argument. The second argument is, when we speak about the interpretations, we have had past interpretations with respect to section 27 as well as section 100. The reinterpretation in a negative way should also be taken into picture, says the author. So looking at section 27 and section 100 of the CRPC will require a new method of analogy and new interpretation, says the author. So putting the blame squarely on the police officers may not be right, is what is this article all about. Now let's look into the next article. This article here is speaking about eradicating the manual scavenging. Supreme Court tells the states the state. So this article here is speaking about manual scavenging. The first important parameter that we have to understand is, what is this manual scavenging? When we speak about manual scavenging, as the very name denotes, it is manual. So we have the night soil or the human excreta. The night soil or the human excreta is removed by the people either through the broom. They just sweep it off and they take it on their heads and ultimately put it in a particular place. So what is manual scavenging? Removing or cleaning of the human excreta, or people entering into the sewage without any precautions, without any safety measures, entering it and cleaning it is what is called as manual scavenging. When manual scavenging takes place, people enter into a sewage or into a pit without any safeguards and they inhale toxic gases, and as a result there are health issues that these particular section of the people face, and ultimately they pass away early as well. Why? Because for a long period of time, if safety measures are not present, they inhale toxic gases because they're constantly made to enter the sewage, they are made to clean that particular pit or the a human excreta in that particular place. There is toxic gas, and as a result they inhale these toxic gases. So ideally, if a person is living for 70 years, 80 years, these people who work in such areas live only for about 35 to 30 years according to statistics. And as a result, in order to prevent the manual scavenging, what we have is two laws. One is what is called as Manual Scavengers and Construction of Dry Latrines Prohibition Act of 1993. The other is the Prohibition of Employment as Manual Scavengers and their Rehabilitation Act of 2013. If we speak about Manual Scavengers and their Rehabilitation Act of 2013, what are the objectives of it? One is to prohibit the construction and maintenance of unsanitary toilets, prohibits the engagement or employment of anyone as a manual scavenger. Violations could result in a year's imprisonment or a fine of up to 50,000 or both, prohibits a person from being engaged or employed from hazardous cleaning of a sewer or a septic tank. Offences under the act are cognizable and non-bailable. So in order to make sure that these people are protected, what we have is the this law in the form of Manual Scavengers and their Rehabilitation Act of 2013. But what is the main issue? And it continues to be still used. That is because people are still being used in this particular backdrop, that they are not supposed to enter the sewage, but they continue to enter the sewage with no safeguards whatsoever. That is because there are no institutional checks and the balances. And even within this particular section, that we have certain section of people entering the sewage and cleaning it, it is only a community, more than 90% of the people from this specific community who enter into it. And as a result, what has the Supreme Court said? The Supreme Court said claims of fraternity, equality and dignity among citizens remain a mere illustration if a certain section of the society is forced to enter sewers for a living and die trapped in them even a decade after outlawing of the inhuman practice of human scavenging. So despite laws, despite the Supreme Court judgments, these people continue to enter the sewage, and then there is death of these individuals. So the Supreme Court has said that despite the ideals of so-called fraternity, equality and dignity, people still continue to enter the sewage. They lose their lives. What is the state doing is the question that is being asked by the Supreme Court of India. And the Supreme Court has also said that in case such people have passed away because they have entered the sewage, a compensation of 30 lakhs will have to be given. Earlier it was about 10 lakhs, now it has been increased to about 30 lakhs as well. So it is asking and directing the state and the central government to take measures and prohibit all these paths that is discussed under this law. It is this that we have to understand with respect to this article. Now let's look into the next article. This article is speaking about one of the places that has been recognized by the United Nations World Tourism Organization, and that place is called as Dhordo. Dhordo happens to be a village which is in Gujarat, and this village has been recognized by the United Nations World Tourism Organization. In a bid to promote sustainable tourism development, the United Nations World Tourism Organization has been recognizing villages since 2021. It is an agency of the United Nations promoting tourism for sustainable tourism. Villages leading in conserving local values, sustainable development, cultural diversity, local cuisine have been the winners. So for the year 2023, what we have is Dhordo, which happens to be a village in the state of Gujarat, which has been selected by the United Nations World Tourism Organization. What was the basis on which it was selected? One, it was able to upkeep with the cultural and natural resource, promotion and conservation of cultural resources, economic sustainability, social sustainability, environmental sustainability, tourism development and value chain integration, governance and prioritization of tourism, infrastructure and connection, health, safety and security. These are the aspects on which the criteria was established, and they were able to decide it is Dhordo, which happened to be for the year 2023. So Dhordo is one of the villages that has been recognized by the United Nations World Tourism Organization in the best village list. Now let's look into the next article. This article here is speaking about Operation Chakra. The Operation Chakra was initiated by the Central Bureau of Investigation. India's Central Bureau of Investigation has launched Operation Chakra, which happens to be a crackdown on transnational organized cyber-enabled financial crimes. What are these cyber-enabled financial crimes? Let's say, for example, you will have a person who will call you. So you will get a call from, let's say, a person who says that he is from Amazon, or a person who is from Microsoft. They say that your Microsoft laptop will not work because the operating system is corrupted. Or there is a person from Amazon. He says that he is a person from Amazon. Unfortunately, both these are not from the authenticate websites or that particular company. So you will get a call back from Amazon, or for example Microsoft, who say that they are from so and so company, and you have an issue within the operating system or within the Amazon website and so on. So, and then they ask you to give the OTP or give you some information, and without the person knowing it, they take away all the information. In order to prevent such things, Operation Chakra has been initiated by the Central Bureau of Investigation. So the CBI is partnering with Microsoft and Amazon as well as national and international agencies to combat and dismantle illegal call center infrastructure. Where do these calls generated from? From the illegal call centers, and these call centers will take the information. So in order to close these infrastructure, the call centers, the process has been initiated. The CBI conducted searches in multiple states, confiscating mobile phones, laptops, SIM cards and freezing bank accounts. CBI is also working with Federal Bureau of Investigation, Cybercrime Directorate and IFCACC of Interpol, the National Crime Agency in the United Kingdom, Singapore Police Force, BKA of Germany to notify further leads. So this operation is basically a crackdown on transnational organized cyber-enabled financial crimes. Why have these companies been roped in? That is because most of these calls are from agents which say that they are from Microsoft and Amazon. And this article further goes on to say, while Amazon and Microsoft will be working closely on the tech part To mitigate threats online, users should also be aware of the tech support calls. So awareness about these kind of calls should also be taken up by you, me. We should also be giving awareness to our parents as well as grandparents, not to, in case they get a call, not to give OTPs, not to give any of the information, because Microsoft doesn't even call. Only when I have an issue, I have to call up Microsoft. Microsoft does not have any of its employees calling us and saying that this is a problem and so on and so forth. Amazon said the customers can view order and communication history directly on Amazon by logging into their accounts and checking the message center. Amazon never asks to make a payment or bank transfer or another website. It only asks for making payments in the mobile app or on the website. So these are the awareness that has to be given to the parents as well as the senior citizens. Now let's look into the next article. This article says Meri Maati, Mera Desh. So this is an initiative that has been taken by the Indian Railways, where they will operate special trains to transport volunteers carrying mitti, which is soil, from state capitals and other major stations across the country. This initiative is part of Meri Maati, Mera Desh, which is a campaign organized by the Ministry of Culture. So remember, Meri Maati, Mera Desh is an initiative that is organized by the Ministry of Culture to pay tribute to the Veers and Viranganas, bravehearts, who made the supreme sacrifices of the country. So we have around 20,000 volunteers who will take the soil from different states. They will move to Delhi. They will reach to Delhi in participating in Azadi Ki Amrit Mahotsav, and then this will help in building a park in Delhi. So basically it is about recognizing the value, the importance of the soil, and also about the integrity of the country. It is this that we have to understand with respect to this article. So this is it for today. In case you're liking these initiatives, please do like, subscribe to our YouTube channel and share it with your fellow aspirants as well. Thank you for watching. All the best.